you very much. Good afternoon, everyone, and thank you for joining us for this important conversation about how to keep people with mental illness and their communities safe and healthy. We know that the criminal justice system was not designed to address the needs of people with mental illness, and yet all too often it's the default system for addressing the needs of people who are ill or in crisis. For example, more than half of the people on Rikers Island have mental health needs, and people with serious mental health illness make up an increasing proportion of those in our jails. This is why the points of consensus that emerged from John Jay's collaboration with the National Organization of Black Law Enforcement Executives concluded that we need to invest in the treatment and services for people with mental illness and proactively address commonly co-occurring issues of substance misuse and homelessness. Given these facts, John Jay has been pleased to partner with the Greenburger Center on this series that asks prosecutors and defenders to share your perspectives on how we can create better laws, policies, programs, and collaboration and coordination amongst all of the offices for responding to people with mental illness. Before we begin this conversation, let me briefly share some information about our panelists and our fabulous moderator, the executive director of the Greenburger Center, Cheryl Roberts. We have a panel of experienced public defenders who are leaders in their organizations and are well prepared to share their insights on the challenges facing their clients, particularly with regards to mental health. Our panelists today are Stan Herman, executive director of New York County Defenders, Joyce Kendrick, deputy managing director of the criminal division of the Brooklyn Defender Services, Joyce Olderman, executive director of the Bronx Defenders, and Lori Zeno, executive director of the Queens Defenders. And as I mentioned, we have a fantastic moderator in Cheryl Roberts, who, in addition to being the executive director of the Greenburger Center, she is also the corporation counsel for the city of Hudson. So she understands these issues from multiple perspectives. And she was also a town judge in Columbia County, New York, and served as counsel to committees in both the U.S. House of Representatives and the U.S. Senate. So now I am turning it over to our moderator, Cheryl Roberts. Thanks, Cheryl.
Thank you so much, President Mason. It's good to be here with you, and good afternoon to our audience and to our panelists. Thank you for being here. We are looking forward to this conversation and learning more about the work our panelists do every day to defend New Yorkers living with mental illness who end up in the criminal justice system. I do want to let the audience know that Tina Luongo of Legal Aid Society is unable to be with us today. At the last minute, she was called to Albany to participate in a rally being held to protest the efforts to roll back bail reform. She did apologize, and she assured me that we would be in great hands with her colleagues, and I know we will be. At the Greenburger Center, we have been honored to partner with John Jay College of Criminal Justice on our series of conversations with the city's DAs and its defenders. As this is our last conversation in the series, I want to extend a special thank you to Carol Mason, president of John Jay, and also Erica Bond, interim vice president of Justice Initiatives. It has been a pleasure working with you both. I also want to thank my staff at the Greenburger Center, Rob Lombardo and Jill Turner, for taking care of all the many details. And now I want to jump into the questions because we have a lot to cover. I want to start with a big picture question to make sure people from upstate who are tuning in know how defender services are provided in New York City. I know I was very confused when I first began learning about the criminal justice system in New York City, because upstate defender services are provided through county agencies. So the staff are hired and fired by elected county officials. In our prep session, we nominated Stan to tell us about how these two services or systems differ and to provide the pros and cons. So Stan, if you could take a few minutes to let us know what it is you all do, how you do it, and how it might be different from upstate.
Thank you, Cheryl, and thank you to John Jay for the invitation. Essentially, when it comes to public defense, there are three models. There are state public defense systems. So if you go to Connecticut, Wisconsin, Colorado, they are all state employees, and it is one state public defender that has regional offices throughout the jurisdiction. In New York State, we essentially have two models. We are all county-based, meaning that we provide our services at the county level, but for the most part, upstate public defender offices are county employees. As you just illustrated, they are hired and fired by elected county officials, county managers. Here in New York City, we are all not-for-profits. What does that mean? That means we have an incredible amount of independence. That means that we feel comfortable standing on the steps of City Hall, calling out the mayor, and not fearing retribution that we may be fired or we may be called into a county executive's office. So what we have in New York City is incredibly important. Independence is one of the pillars of the ABA's model for creating an indigent defense system. Here you have all the borough-based public defender offices. So my office operates in Manhattan, Justine's in the Bronx, Laurie is in Queens, and of course, Joyce is in Brooklyn. We represent collectively tens of thousands of individuals who come to the criminal legal system. And that's pretty much the overview.
Thanks, Dan. Very helpful. And it is amazing to me how very different the two justice systems are, upstate and downstate. So I want to go to the next question because we heard from many audience participants over the course of the last 6 sessions with the DAs, and frankly, even from some DAs, that the process to get someone into mental health court can take a very long time, and that defendants are sometimes required to provide detailed and traumatic details and information to the prosecution or others multiple times before the client is considered or admitted to mental health court. So though I am loath to suggest anything that normalizes the criminalization of mental illness by further institutionalizing it, I wonder how you all feel, and would you support, perhaps through a contract with one nonprofit or maybe a government agency, the creation of a dedicated group of mental health professionals to do timely, independent, and confidential mental health evaluations of your client. Defenders would then get the full assessment results, but the court and prosecution would get a summary of the report, including perhaps recommendations on whether the defendant is a good candidate for diversion and then a recommended treatment plan. That way, it seems to me, all defendants across the city would get the same level of evaluation, no matter where they were arrested. And maybe most importantly, the assessment would also occur in a trauma-informed environment. Hopefully, courts and DAs could then feel confident in the assessment and speed up the time it takes to get decisions made about mental health court admissions. So is this overly simplistic? What are the pros and cons? And are there other ways that you think could better reduce the client's trauma and time it takes to get to mental health court? So I would like to start with Joyce on this and pass it over to you.
I don't think that I would be in favor of that, only because I feel like that may lend itself to even more crinks and in how it plays out. I could tell you how we do it. I think that the way that we do the process is probably the fastest, because as soon as we get a case referral from one of our attorneys, they have what they call like a gatekeeper ADA in Brooklyn, and we go directly to him. We only have to write up a short synopsis, or maybe it's a conversation, and we basically have to know our client's diagnosis and the medication that they're on, and we simply say to him that we think this client should at least be evaluated in mental health court. And we built up a trust over the 20 plus years that we've been open, so that ADA Kelly, who is the gatekeeper in Brooklyn, really trusts that I know and my team knows exactly is really eligible for this part. And so from there, he says yes, it's a green light into the part. We immediately get him scheduled for a evaluation by a psychiatrist and by the social worker. And so I think it streamlines the process. We don't have to necessarily do anything more than that. In some cases where it's very serious case, like a gun case or a very serious charge, or sometimes in PTSD cases where the client's diagnosed with PTSD, it requires a PPI. That's when you're talking about the re-traumatizing of the client, right? Because the client will tell us what their situation is, but then they also have to speak to a social worker who writes the PPI. Then they're evaluated by the doctor and the social worker. But 9 times out of 10, we eliminate that stuff. The only time the client really sits down and tells their whole story is when they're actually in the evaluation. They are not requiring in Brooklyn that we have a PPI up front, or that necessarily we even provide medical records. And even if they do, it's very, very limited. We get the client in pretty quickly. And I think that's a good system. I think if you over-regulate it, it's going to take too much time. And it's like, why broke what works for us? I wouldn't want that to come into our courts.
Thank you, Joyce. One of the reasons I directed that to you is because I know that you have in Brooklyn the longest standing mental health court, I think, in the country, certainly in New York. And so I wanted to hear from you. I also, if you would just explain to the audience what PPI is.
Oh, I'm sorry. It's a pre-pleading investigation. That's where the client sits down with pretty much in our case, a social worker who goes through their social background history and talks a little bit about their mental health history. And then that report is prepared and given to the ADA who's assigned to the case.
So I want to ask maybe Stan or another of the defenders about your process, because it seems to me like what we heard is that the process that Joyce described, while seems to be smart and efficient and work well, is not the process that plays out in other counties. And it does seem to me that there should be some standardization, or at least an ability for a defendant who happens to be in Brooklyn, as opposed to, the Bronx or some other jurisdiction, to get some level of the same treatment. So can you talk about what you might need or how you could see this process?
So Manhattan is the antithesis of what Joyce just described. And, the re-traumatization of the client is something that occurs 4, sometimes even 5 times. Now, I need to put this in historical context. We're coming off 12 years of DA Vance and, 3 decades of ADA Morgan or District Attorney Morgenthau. And so we're still waiting to see how this is going to play out under DA Bragg. But historically, what has happened in Manhattan is that first our office would have to do a full PPI to prepare for the line ADA, who's in charge of the prosecution of the case. The line ADA will then review it. And if they think that it's worthy, then they will ask the client to be brought in for a proffer. So now you have to prepare the client, bring him into the proffer, sit down with the line assistant, where they essentially have to confess for what they're charged with, and then talk about, why they are deserving of mental health court. After that, the DA will then probably get their own forensic evaluation of the client to make sure that they have medical support. And then if you get past all of that, then you get to the treatment court. So by this time, the client has probably been evaluated about 3 times, and now you're into treatment court, and then the process starts de novo. It is incredibly slow. In Manhattan, it could take 7 to 9 months to get somebody into treatment court. It is very charge-based. So the district attorney has historically made a distinction in terms of who deserves help for mental health issues and mental illness based on the charge. So if you committed a larceny, they may deem you worthy of getting help for your mental illness. But if that very same person commits an assault, then based on the charge, they were deemed unworthy. And so it is a very inefficient system, and it is certainly one that needs to change. And we hope that DA Bragg will do so.
Right. And again, I wanted to juxtapose these 2 boroughs because it seems like they are very different. And I don't know, Justine and Lori, if you want to add to that, or if we want to then move to talk about, well, how can we fix this, disparity in treatment and the length of time? So Lori, Justine, you want to add to what happens in your jurisdictions, or move on to some ideas about what you would have to fix these issues that we've just heard about?
I'll just share really quickly, and then Lori, I'm going to kick it over to you. We sort of fall somewhere in the middle. I think we're not quite where Stan is, but the delays in getting people into treatment, getting assessed, getting evaluated, we have seen change with our DA, more of a willingness to at least assess the possibility of treatment court for people, even those who are charged with what our penal law describes as violent felony offenses. But the delays are extremely, extremely long. And I know we're going to talk about this, but I feel like I would be remiss not to circle back to what you said at the beginning, which is at the, risk. I don't want to do anything that further institutionalizes it. But when you begin to see that there are issues in the efficiency, the efficacy of a system like treatment court, you have got to be raising the questions about not how do we fix it and make it faster. Obviously, that's a piece of it, but that cannot be in isolation. We have to be asking ourselves the broader questions about why so many people are being cycled into the criminal legal system with, those profound issues that they're struggling with and how we're failing them in the first place.
Bravo, well said. Thank you.
Cheryl, I guess what I would add is, as Joyce was explaining how it works in Brooklyn, I thought to myself, oh, wow, well, lucky Joyce has been there for 19 years and they've built up this trust. What happens when Joyce leaves? Is it going to be another 19 years for the next person to build up trust with, whoever this gatekeeper is before, where they'll just take your word for it and let the person in. So that's great for Brooklyn right now. But, that's the problem, I think, with those kinds of operations. And so if we're looking at something long-term and something that is going to be equal throughout the state for everyone and not, what's going to happen in Manhattan and what's going to happen in Brooklyn and Queens and so on, because we're kind of somewhere in the middle as well, like Justine said. But for me, I guess we're one of those larger not-for-profit organizations that, came into the justice system 25 years ago. And, and I do believe that while I don't like institutionalizing things either, but I think in this situation, it's certainly better than what we have now. I think all of our organizations have been examples of how we can, be more efficient, bring more efficiency into the criminal justice system. And while that's not our goal, right, it's still being efficient helps our clients, right? Because if we have ways in which we can do things faster or more efficiently, then our clients are out of jail sooner, or, however it is that it works. And, and for me, if there was an individual organization that handled that kind of stuff, right, they could take into consideration, I would assume it would be through the medical community. And so they would take into consideration what is the process like and what kinds of, what does their space have to look like to make people feel safe, and how how they're treated or what they're told, that, especially when I think of a situation where somebody who's charged with a crime, suffering from a mental illness, having to appear in front of a DA and essentially confess, having no idea what's going on, even if, they know who the judge is and who the lawyer is, but they have no clue about what's going on. And that's just barbaric in my mind. Just the whole emotional turmoil. Just all of it's like, what are you kidding? So that's my position on whether or not I think at least one organization or more, one in every borough, one, citywide, I'm not sure, but it seems to me that this system is broken, very badly. And it's not just little things, they're big things. And so maybe it's a big fix that has to start right away. And my feeling is if, it's like the definition of insanity, right? I mean, we've been doing things the same way forever and things are terrible. So it makes sense that if we keep doing what we're doing, things are going to stay terrible. If you want to make a change, you got to change what you do, and will this be the ultimate answer? I don't know, but I would much rather try something, and then if that doesn't work, okay, then we'll tweak that as well. But to keep doing what we know isn't working, it's insane. It really is.
I hear you. Okay, I wanted to talk about stumbling blocks to success in the mental health court. So we just talked about the stumbling blocks and problems getting people into mental health court and the delays and the trauma. But once someone is in mental health court, what are the difficulties that you all have encountered? Is it lack of diversion options? Is it lack of residential options? Is it, judges and DAs not agreeing to the disposition that maybe has been suggested by clinicians? So I know, Lori, we're going to start with you on this question, and then I'm going to move on to the other defenders too, because I think this is a critical gap. If we can finally get someone in and then we still can't help them, then, we have to really rethink.
Yeah. And all of the above, everything that you said is a problem. When I said before the system is broken, I meant what I said. It's broken from the beginning to the end and everywhere in between. And this is such I don't know, the clients that are involved, all clients come in and, you have to find some compassion, right? Because they're scared or they don't really understand what's going on. But when you talk about somebody with mental health problems that, they were born with, or, it's not their fault, and it's just, they're just so much more compassionate because, people just seem to think like everybody has to think for them and make their decisions for them, and they just get bounced around, frankly, from the get-go. I mean, even people and all the people, I mean, think about people that go into the mental health court, right? And they get accepted within the criminal justice system. They're few compared to the number of people who are affected by mental health problems, right? So when you think about all of those people, then it's really broken, where at least some of the people that go into the treatment court, they get a little bit more, if, even though it's still not what they should get. But what I mean by that is, we can't, as the legal, people in the system, we can't do this alone because, we need to have the medical profession involved in this, and we need to have the medical profession available. And it's not, it's just not. I mean, people with mental illness, they're known already in the community, oh, that's the guy who, was kicking cans last week and whatever, you know what I mean? It's like they're known. So then right away, the people in the community treat them differently. The police treat them differently, more violently, because they get to say, well, this person's crazy and they were acting out, and so therefore it's okay that I do this or that. So and then they're taken to jail most of the time. If they go to an emergency room, you're lucky if they keep them overnight. It's like a revolving door, literally. They'll go in, they'll find some way to say that they're not a danger to themselves, and they can't say they're not a danger to others, but if they're not a danger to themselves, so they release them, and maybe they give them a prescription, which, you know, goes nowhere, or they don't, but they release them, right? And then what happens? Now they've been traumatized, right? They've been at the hospital. They've had all this stuff happen to them. So they're agitated. And then they just, you know, we're like, there you go. Good luck. You know, whether they're homeless, whether there's a place for them to go or anybody to go to, nobody knows and nobody cares. And what happens? A week or two, guess what? They're back. They're back because, you know, they haven't had anything that they needed to have after this action takes place, right? And then their disorder gets heightened, and now they're back out in the community who treats them badly, where the police treat them badly, and they're homeless and they are unmedicated and blah, 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 right? And then boom, you know, here we go, another crime is committed, and then they're back in the same cycle, you know. And I have literally been on the phone with doctors from emergency departments all over Queens and had threatened to sue them. I've, you know, begged them to keep a client overnight or for 3 days or anything, just keep them, because they just can't get put back out on the street again. Give me a chance to find some sort of outpatient something or other, but they just don't do it. So we don't have the time even, because they're right back out on the street again and they're not safe. And, you know,
Yeah.
it's, and the programs they do have for them out there, shelters, right, for people who are homeless, or some sort of alternative to incarceration, a program maybe that they go to for the day, or if they don't, it's not an inpatient, it could be an outpatient. But that's also very hard because, you know, those programs aren't safe, right? And they're just like, they're there as an alternative to incarceration, but they don't necessarily know how they should be treating people with mental illness when they're there, right? So then something goes wrong. Like I had a client who was in a homeless shelter and she was abused the night she went in, an incident, a terrible incident. And so she left and came to the office and begged the attorney here to bring her back to the judge so she could go back to jail, because she was too afraid to go back to the shelter. And long story short, you know, our lawyer is telling her, well, I can't bring you to the judge, and the judge isn't going to put you back in jail because you didn't commit another crime, you know, and maybe we'll find another shelter, maybe we'll this or that, right? But I can't, you didn't commit a crime, so you can't go back to jail. So what happens? You know, she leaves the office and gets into an elevator and punches a woman in the elevator because she was like, okay, now I committed a crime. Can you take me back to the judge now? And can you put me back in jail? And, you know, how sad is that?
Yeah. I think you know, Lori, I think the things that you're saying really point to some things that Erica Bond and I were speaking about right before this. And that is the failings of the mental health system. And while we've been asking you all what to do with folks who are in the criminal justice system, we need to ask the bigger picture questions, which is something that Justine mentioned too. And it really brings up the treatment not jails legislation that I know Stan really wants to talk about. I just want to ask quickly though, to Lori and Joyce and Justine, if they have particular specific obstacles in getting people into the treatment that they need. And then I want to close out this question with Stan talking about treatment, not jails. So Justine, you want to talk about in your jurisdiction, what are your—
I'll just say really quickly that I think, you know, the problems in getting people appropriate treatment is, to Lori's sort of point, is sort of mirroring the problems in the community, right? So we tend to sort of paint people who are struggling with mental health issues with a broad brushstroke. We sort of lump people together. We take sort of a one size fits all approach. There are like sort of these two options, and it doesn't account for a whole, the fact that the issues people struggle with are not siloed, right? So somebody may be struggling with a housing issue, housing instability, and also have a mental health issue. And when they get to treatment court, the assumption is that therefore they need residential mental health treatment. But that may be for people who have, a different set of circumstances. Maybe their mental health issues require that kind of setting, whereas somebody else doesn't, but we don't have the supportive housing to also couple with what is a more appropriate outpatient treatment. So I'll just leave it at that, just to say, like, there isn't nuance. It's a mismatch, oftentimes. And because that is operating within what is essentially a criminal punishment system, it is often a setup for failure.
Yeah.
I'll kick it over to Joyce.
Yeah. Thank you. Joyce.
So in my experience, what I find to be the most difficult to get clients out once they're in treatment court, to get them actually out of jail and into their treatment, is the lack of residential programs. For the most part, if clients have somewhere to go, they have family members that are willing for them to stay there, then we can get them out much quicker. You're talking about, and I like to talk to my clients and say, you're looking at about a 4 to 6 week turnaround from the time that you start the evaluation to the time that you're walking out. If they have to find them a place to live, a residential placement, then it can be much longer. It can be a few months. And what we do in our part is, at least, and I'll just say, going back a little bit to what Lori said before, I have a team. There's 8 or 9 attorneys who also are on the mental health team that are designated to that part. So I hope to pass down everything that I learned so that whoever comes behind me is also able to pick up the ball and run with it, so that we keep things going. It also matters about the DA, right? We have a DA who is open, Eric Gonzalez, who is open to these types of programs. And so they make that attitude makes it much easier for us to get our clients in and accepted into mental health court. So that's really huge. But once we have them in, I find that what most delays it is when we have to find placement for them. There needs to be more residential placements available.
Thank you, Joyce. Stan, do you want to talk about treatment, not jails?
I do, but even before we get to treatment, not jails, I think what we're all saying is that there needs to be monumental investment in mental health services, in housing. When you look at the billions of dollars that we spend on NYPD, on the probation department, on parole, on DOC, and you compare that to the amount of money we invest to help people, I think it's about 10 cents on the dollar, right? So we have made a decision that the way we're going to deal with all of this is to try to incarcerate our way out of this problem. And it simply doesn't work. My office represents Marshall Simon. For those who don't know, Mr. Simon is the individual who is accused of pushing Ms. Go to her death at the New York Times, at the Times Square train station. And what's been reported publicly in newspapers and in the news is how mentally ill Mr. Simon is, and how frustrated Mr. Simon was for years trying to get the help he needed and was just rejected, discharged too early, told there wasn't a bed, told there wasn't resources. And as a society, we see individuals like Mr. Simon every day on the subway. And what we all do is that we don't make eye contact, we look away, we play with our phones, and we just hope that somebody else will deal with this individual. So collectively, I say that we are all responsible for what happened to Ms. Go. And we all have to do better. And that means investing in the infrastructure that folks need so they get the help proactively. I know we're all defenders here and we're all talking about the legal system, but you've really failed those individuals if you're waiting for them to get arrested and then turning to us and the courts and say, fix the problem. So we need proactive investment, proactive outreach so that these folks never end up in the criminal legal system. But if they do, there is a wonderful bill that is currently pending up in Albany. And our sponsors are Senator Jessica Ramos from Queens. And I'm going to give you the bill number. It's S2881B. And we have Assembly Member Forrest from Brooklyn. And the Assembly bill number is 8524A. And essentially, this would codify mental health and treatment court in our penal law. We currently have an article that addresses this for drug diversion, but not for mental health. And this would go beyond just substance abuse. So this would be physical disabilities, intellectual disabilities, trauma, brain injuries. It would not be charge-based. So we would be helping the person irrespective of what they may have been accused of. And it also would not require a plea up front, right? We know that most people are successful in treatment when they are voluntary participants and not forced to enroll in these programs. Currently, and I'll end with this, there are 30 ad hoc mental health courts throughout the state. We have 62 counties, I think it is, in New York State. So less than half have mental health. But what is startling is that OCA's own data says that 140 people were serviced in the year 2020, statewide, not in Brooklyn, not in the Bronx, statewide. That means 5 people per court, per county are in help. That needs to be thousands of individuals who are being helped. And so the other thing this legislation does is that it takes the prosecution away from being the gatekeeper. You want to talk about giving judges discretion? How about giving them discretion to give individuals before them the help they need and not require prosecutorial consent? So please reach out to your elected officials. Treatment, not jails. If the governor wants to do something, if she wants something that I think everyone can get behind, it is treatment, not jails.
Thank you, Stan. I appreciate it. I think it's a good segue to the next question I was going to pose, which is about bail reform. Very, controversial, important topic right now. And I know there will be some decisions made by April 1st about this. But Justine, I want to pass it to you and ask you to talk about certain provisions of the proposed bail reform. I guess the governor's 10-point plan it's how it's referred to, specifically about giving judges more discretion, as Stan just talked about, but in this case, discretion with respect to dangerousness when setting bail. So I think some people would say, well, isn't that what happens? Doesn't a judge already think about whether someone is dangerous? And shouldn't they think about whether someone is dangerous if they're going to set bail? Talk to us about that and why that is not necessarily a good equation.
Yeah, I would just want to start out by saying I appreciate the opportunity to talk about that here, because the concept, as you just laid out, sounds super reasonable, right? Shouldn't judges have the ability to do that? So there are a couple of things to know about the current debate on adding dangerousness to the bail statute. The first is that this debate is not new. New York has been having this debate since 1970. New York really sort of stood fast when sort of the tide was turning around the country, and the feds and states across the nation were adopting a dangerousness standard. And New Yorkers keep coming back over and over again to the decision not to add it. And there's very good reason for it. The first reason is that it doesn't work. It doesn't achieve the goals that everybody thinks it's going to achieve in terms of public safety. So if you look right now, most other states do have a dangerousness provision in their bail statute, and most cities like New York have seen an uptick in gun violence just like New York does. There just isn't any correlation between what we're seeing on the ground and that particular aspect of bail statutes across the country. The second thing to know is that it's not just that it hasn't worked, it literally can't work. So there's tons of data and social science research out there that shows that, at least coming out of New York, that the number of people with an open case that get rearrested for a violent felony offense is less than 2%. So imagine what that looks like from where a judge sits. You have 100 people And you have to try to figure out which two, less than two, are likely to go out and get rearrested. And we're not talking about convicted, right? Because we're just, all we can really track in that regard are rearrest rates. We know rearrest rates do not correlate to guilt. It does not correlate to conviction. They're not a 1-for-1 ratio. And so you begin to understand that the likelihood of being able to figure that out, it's like finding a needle in a haystack. And then people naturally ask the question, well, what about risk assessment instruments? Isn't that the answer? Isn't that how judges can figure out who that, it's 1.7, that 1.7 percentage of people that might get rearrested for a violent felony? But we know from the most recent data on risk assessments that they are simply, first of all, the data that goes into them, when we know about, not just in New York, but across the country, that policing is inherently discriminatory. It's inherently racist, that the people who are coming into our criminal legal system, they are not coming in proportions that mirror their population, nor are they coming in proportions that reflect the true nature of what is happening in terms of crime in our cities or across the country. So we know if we have a problem with racism in our policing practices, the data that goes into informing risk assessment instruments and predicting the likelihood of future contact with the police is going to have the same biases. Even at its best, the rate of predictability in those risk assessments is nothing that anyone should be proud of. What will ultimately end up happening, and what we have found happens, is that in places that have adopted risk assessment instruments, the number of people incarcerated, because we don't have a crystal ball. Nobody can predict the future of human behavior as much as we might like to. It actually increases the number of people who are getting detained on bail. And in New York, that would mean exacerbating what is already a stunning humanitarian crisis at Rikers Island.
Thank you, Justine. Does someone else want to add to that before I ask another bail reform question? I thought I heard someone. No?
I think the only other thing I would just add, if not, is that, without a risk assessment instrument, right, what we know happens, I just want to circle back to your point, Cheryl, which is like, isn't that what judges are already doing, right? Against New York, judges are not allowed to do that. They aren't allowed to consider dangerousness. And if you codified what we already know is happening, but at least we have the tools to fight against as defenders on behalf of the people we serve. If you codified it and then didn't provide anything because it doesn't exist, a tool that we could rely on for predictive purposes, what you're doing is you are injecting even more bias and discrimination into the bail setting process, which is already something that we are fighting against each and every day.
Does this issue of dangerousness have more or less to do with people with mental illness who come into the criminal justice system? Does it impact them differently than it might impact someone who doesn't have mental illness?
I mean, I think the same way that what we know is that the concept of dangerousness has historically, and I don't mean historically like tens of years, I mean hundreds of years, been equated with Blackness in our country. The same issue applies with mental health. When we're talking, if you talk in the abstract about how we feel about people with mental health issues, right? The way we feel about people as a society with mental health issues is not equal across the board. It depends on who that person is. It depends on what they look like. It depends on what socioeconomic class they come from and how that manifests itself. Right? When it comes to the people that we serve, like Mr. Simon and Stan that you were talking about, the people that we see on the subways, those are people that we have come to fear. And I put those two things in one sentence because they are related. The same way that dangerousness has been associated with people of color in this country, historically, it has also been associated with people who are struggling with mental health issues, especially when we're talking about people of color struggling with mental health issues.
Thank you. So now this is not necessarily related to people with mental illness who are criminalized, but I think it's very important. So I'm going to ask it. I'm going to be selfish here and just ask this question because I'm interested myself. But one of the bail reform provisions has to do with discovery. And the current law is that prosecution has to give over information, has to give the discovery material to the defendant, which seems to me should happen. If you're going to be charged with something, we should know, your defendant should know what information is being considered against them. But there's this standard that is being considered to amend the new discovery rule that would allow a case to go forward, even if the prosecution held back information or discovery material, if it was substantially compliant, if the DA substantially complied with the requirement to give over all the information. I'm not quite sure which one of you would like to talk about that, but I'd like to hear a response.
So we need to understand that prior to the discovery change, we had the worst discovery laws in the country when it came to criminal cases. And, you know, my first question is substantial compliance. What does that mean? Ask Barry Scheck what substantial compliance looks like in the context of innocence cases. You turn over the material that you have in your possession that you're required to do so. If you get into a car accident and you sue someone, you get all of the discovery that you are entitled to. And all the discovery law did was bring that level of fairness and due process to our criminal statute. And this idea that's, you know, kind of percolating out there, that cases are just being dismissed left and right because, you know, DAs are incapable of providing discovery, is just a false narrative. They have been given something like $50 million to implement discovery. This is 2022. Get your systems in check, hire enough people, and turn over what you're supposed to do. And from what I see, and I carry a caseload in Manhattan, I haven't gotten any of my cases dismissed 30-30. DAs are turning over what they're supposed to do in a timely way. So I think it's a false narrative. It's one that somehow is going to reward prosecutorial laziness instead of getting the materials that are out there in a computer system and simply turning them over.
It doesn't just encourage ADA district attorney laziness, frankly, it encourages district attorney misconduct, which is something that we've dealt with for many years. And, you know, their ability to hide discovery, if something is written in the report or, you know, that helps the defense, you know, then they can hold that back and give it, you know, at the last second, or if not at all. You know, and like Stan says, you know, in a civil case, if you have a car accident, when there's money involved, you don't just get the discovery you need. I mean, everybody in the case actually testifies in depositions before the trial, so that by the time you go to trial, you already know, as the attorney, what everybody's going to say, because it's already there in a transcript from, you know, months earlier. So it's like your second bite at the apple, you know, when you're at trial. And, you know, yet people seem comfortable with taking somebody's liberty away and putting them into prison without allowing them to see what people are saying, what witnesses are saying, what cops have said, I mean, it's like mind-boggling. And even in this section where, you know, where the governor is talking about changing the discovery, I mean, it's because the DA is complaining that it's too quick. Like they want more time to be able to turn it all over with. Like, so let's let somebody sit in jail even longer, you know, while the DA, you know, comfortably gets all the discovery. They don't want to have to rush. It's like, are you serious? You know,
and Lori, if I may, because let's educate the public about the timelines.
Yeah, exactly.
You have 90 days on a misdemeanor and you have 6 months on a felony. So this isn't a matter of a couple of days or a couple of weeks. They have months to turn over this material and answer ready for trial.
You know, honestly, if I could just add one thing, right? I love it how they take these, you know, discovery rules or the bail rules or whatever. It's all based on fear, right? I don't know who comes out with it. I don't know if it's the DAs, I don't know if it's the governor, I have no idea, right? But it's all fear. I remember when Discovery first came out, the big thing was, oh, we're going to have to give the defendant the names and addresses of rape victims, which was total bull, right? But that's what everybody said. I mean, I swear to God, it's like they just make this stuff up. And they say it, and when they say it, it becomes true. And then, they don't even know what they're talking about. And and all they do is scare people, scare them, and then people will let them change laws.
I hear what you're saying. I want to just actually, we have a question from the audience. We only have a few more minutes, so I want to try and get at least one audience question here. And before we close it out. So the question is about Manhattan. It says in Manhattan, how do you respond to clients who may not be willing to admit guilt, but still need mental health treatment? And in the other boroughs, similarly, what are the other options, if any, that exist to support clients who can't access mental health courts? So let's start, I guess, with Manhattan. Stan, what do you do with a person who's not willing to admit guilt but needs mental health treatment? And is that a relic of the last administration, or is that still an option here or a requirement here?
Right. So, what we've seen traditionally in Manhattan has always been that you have to plead up front, even to be considered for the treatment. So it's almost a game of gotcha. It's like, first I'm going to get you to plead guilty. Then I'm going to, traumatize you about 5 times. And more often than not, we're rejected. So you've already pled guilty, you're being denied treatment, and now you're going to jail. We know that people are more successful when they get in programs voluntarily. And that doesn't mean that you don't ultimately resolve the case, right? Are they charged appropriately? Are they overcharged, right? Should the person be given a misdemeanor charge to resolve a case on a felony if they've successfully completed their case, their treatment? So it's not that we're not going to get to the disposition part of it. We will resolve the case appropriately, but we're just saying, let's get the person the help they need, and then we could work on resolving the case afterwards.
Does anyone from the other boroughs want to comment on what do you do with a client who basically can't access mental health courts?
Sure. I mean, we do everything that we can to find community programs or any sort of, alternative, to incarceration program, if it's inpatient, outpatient, and then we try to resolve the case with them being able to go on the, outside. Thankfully, some of the other judges, not just in the treatment parts, right, are open to those kinds of things, depending on, who the client is and what the program is and things like that. And we just do the best that we can. But something that Stan said about how, they force them to plead guilty, and then, they still end up with that felony conviction, or at least it should be a misdemeanor conviction. What I find interesting is in the drug treatment courts, they don't make you plead guilty. And when the case is over and you've completed your drug treatment, your case gets dismissed, sealed, gone, like it never happened. Yet mental health problems that people are born with, there's issues about drug abuse, right? I mean, did you make a choice? Is there some kind of, accountability for the actual person before they became an addict, or so on, right? But in those cases, we'll dismiss the cases outright. In mental health cases, we have to make sure they have that criminal record.
Right. Joyce, how about you? What's going on in Brooklyn, and what do you do when a person, can't access your mental health court for whatever reasons, but still has a mental health issue? Are there options?
Well, what we do is we have a great team of social workers who will sort of, as Lori kind of alluded to, that will find alternative treatments for them that we can get them in on our own. And then we just try to work out the best plea we can as far as their criminal case. But we do try to get them into treatment if they're willing to go. You know?
So you do that through a regular criminal part, not a mental health part?
Right, and the regular criminal part.
Okay.
But Cheryl, it should be clear, those are cases where the person's not incarcerated, right? Where the person's out and we could get them those services. If the person is sitting in custody, then there's no treatment that we're going to be able to get them without prosecutorial consent.
Got it. Okay.
And Cheryl, I'll just pipe in that, especially since this is not just New York City, as you pointed out, there might be upstate people. This is an argument for a well-funded defender system and defender offices, right? The resources that my colleagues have been talking about, you know, that requires like people with expertise in the issues. It is also, you know, going back, and I know you're going to have other conversations about outside of the criminal legal system where the, you know, deficits are, but it is also an argument for really looking at pre-court diversion opportunities, you know, even before you get to treatment court and not requiring an upfront guilty plea, but actually saying like, you know, maybe there's a possibility that when people, there is like a moment where like they could go into the criminal legal system to see that as an opportunity instead of just trying to make things better down that path, really seen as an opportunity to divert people at that moment away from the criminal legal system altogether.
You know, absolutely, Justine. And you know, we've had him before, but I always love to hear Judge Leifman speak from Florida. He talks about exactly that. He calls it redirection. So it's not diversion. It's not an alternative to incarceration. It's redirection. You come in at the arraignment and he doesn't even arraign you. He just says, look, you need to go to get treatment and, you know, don't come back. Like, let's try and get this, get you connected now. So you don't have to come back here. There's nothing over your head. You just go into treatment. Now that doesn't happen with everyone, but his redirection programs are successful. So I'm going to end here by saying, first of all, thank you so much for what you do every day for the people of the city of New York. It's very impressive. And I really think that you're right, Justine. We need to look at a holistic approach to providing defender services that don't depend on where you happen to be, upstate or downstate. You know, Erica and I also spoke about, as I mentioned earlier, the need to look at this system or this problem more holistically, to look at it from the root cause, which isn't you all. You're the people left holding the bag, and so are the police, actually. The real problem is upstream. And so we will be putting together some programs on that, a series, I think, on that, but we don't have the details now, but we'll be back in touch. So I want to thank you all so very much for your time and the work that you do. And for the rest of the audience, thank you so much for your time. And we'll be back in touch shortly with more programs. Have a good
Thank you, Cheryl. Thank you, John Jay.
Bye.
Thank you.